Before we start, I hear my phone. Can I take a phone call, please?
Sure.
Excuse me just a minute. Hello? Oh, hey, DJ. How are you? Yes, I did. I graduated from the University of North Carolina. It's DJ Burns from NC State.
Oh,
Yes. Oh, you admired Carolina and the coaches and the way they play defense, and you want my advice about how to play defense on that big 7'4" guy from Purdue here in the Final Four. DJ, I can't help you. You're just going to have to listen to Coach Keating. He looks like he's doing a good job. Yes. Well, thank you for calling, and good luck to you. All right. Goodbye.
stick around. See what happens next on Suits and Boots Legal Talk. Well, good morning. It's good to have you guys. We got a full house this morning. We've got David Benbow, Kolin Funk, and I'm Luke Martin. We're all attorneys at Benbow, Davidson, and Martin. We're here with another episode of Suits and Boots Legal Talk. So today, we're going to be talking about not March Madness, despite what you may think, but we're going to be talking about how to preserve assets. So what happens when mom or dad has to go into a nursing home or something like that? And do we have to worry about the nursing home taking the property? So a lot of times that's a question we get. So I think one of the most common ways this comes up for us is someone comes into our office and says, hey, I want to give my real estate to my son or my daughter or my children. And David, is that a good idea?
Well, sometimes it is, and sometimes it isn't. When I have a client that asks me that question, I go into detail with them and say, why do you want to do that? And how is your health? And you might say, well, why do you want to know how their health is? Well, sometimes they'll say, well, my husband has dementia, and it's starting, and we're not able to take care of the farm anymore, and we just like the children to have it. Well, the key word there for me is dementia. Unfortunately, we're seeing more and more folks that have dementia as we get older. And to me, that says, hey, there's a possibility of long-term health care down the road. So what I have learned is that of the three of us sitting here, the statistics show, and this is awful, but the statistics show that two of us are going to need long-term health care sometime during our lifetime.
Sure.
You guys are a lot farther away from that than I am.
Maybe.
But maybe, yes. Because there are other reasons for long-term health care, like a tractor trailer moving over into your lane. This happened to me when I was going to see my grandson play baseball the other night. And but at any rate, the statistics do show, and I looked them up before I came, that two of the three of us are going to need long-term health care.
And that's important because long-term health care isn't covered by Medicare, right?
That's correct. Medicare will just pay for a limited number of days when a person needs to go into long-term health care. They may call it rehab or something like that. But then when it runs out, if you have long-term health care insurance, then that'll kick in, and depending on what kind of policy you have. But, of course, most of us don't think about long-term health care insurance until we get so old that it would cost too much to purchase it. So what the average cost in North Carolina of a assisted living is $5,716 a month. The average cost of a semi-private skilled nursing in North Carolina is $7,422 a month, and that's $89,000 a year.
Yeah.
Or private skilled nursing is $96,000 a year, and these costs are rising.
Sure they are. Yeah.
Tremendously.
Yeah.
So I want to know about the family's health situation. I want to know about all of the children when they just come in and say, I want to do a deed.
Yeah.
And we're going to find out why.
And as you talk about that, so Medicare doesn't cover the long-term health care. So now we have to self-pay.
Yeah.
And that's $80,000 a year, or we have to qualify for Medicaid, right?
Right.
And that's where the rub comes.
I'd say about half the time folks don't have any money to pay that $8,000 a month or $7,000 a month. But half the time they have a couple $100,000 that they've saved through the years, and that has to be spent down before Medicaid will come in and start paying.
Sure.
And when I say spent down, what I'm talking about is it has to be used to pay the long-term health care facility. And so let's say that lady comes in to see me, her husband has dementia, she wants to give the property to her 2 children. One lives in California and she hadn't seen him in 6 or 7 years, but the other one's right there on the farm helping look after the farm. And let's say that her husband's dementia is such that he's still at home, she's looking after him, but it's getting harder for her to look after him, and the son next door helps. So I explained to them what we just talked about, the cost, the odds of long-term health care, and they do increase substantially if a person has dementia. And certainly there are other reasons for someone needing long-term health care. And then I explained, after I found out what other assets they have available, that this lady that we're using as an example had $200,000 saved up. Well, I've explained that that'll last about 2.3 years of long-term health care.
Yeah, yeah.
And there are other expenses that people have. So we can't predict when we're going to die. We
Nope.
can't predict with certainty things like that.
And thank goodness we can't.
No, you're right. I agree. I agree. But there are things that she can do to pre-plan for this. Now, you might say, well, why doesn't she just give this farm to the son?
And that's what everybody wants to do.
They want to do.
Yep.
So the quote unquote, so the nursing home won't get it.
That's right.
Well, the nursing home's not going to get it, but the long-term health care facility is going to be paid, and if they don't get paid, then your loved one's not going to be able to stay there.
Right.
So when we start talking about how we're going to pay for this and what can we do, I explain about Medicaid, and I tell her why she should not. Certainly she's legally has the right to deed it over to her son if she wants to. But if she does that, she makes her husband and frankly herself, because in this hypothetical the deed is in both their names,
Sure.
Ineligible for Medicaid for 5 years. A certain percentage of Medicaid, it varies. There's a formula they use, but it's called a 5-year look-back period. It used to be a 3-year look-back period. It's now a 5-year look-back period. And what that means is if she goes in to apply for Medicaid and she's given this house or this farm away to her son, Medicaid is going to ask about, what in the last 5 years, what have you deeded out? What have you given away? What gifts have you made out of your bank account? They'll want to see all your bank records. They'll check the Register of Deeds. They'll check the tax office, and they'll find that she's given this farm away to her son. And they will say, you're not eligible for Medicaid.
That's right. And it makes sense that they would do this because you could have a multimillionaire who, on the eve of needing Medicaid, just says, "Oh no, I've got so much money, they're going to take it all. It's going to cost so much. I'm just going to give it all away, and then the next day go apply." And that's not just.
It does make sense, but whether it makes sense or not, it's
the rule.
law.
Yeah,
that's the rule. And that's the law. And so, what do? Well, in this scenario, there's the one son that she wants to have the farm, and the other son that she hadn't seen for 7 years. She said, "Well, I think I'd just rather have the son who lives here to have it, and so would my husband." So I want to make sure that they have a health care power of attorney and a general power of attorney, a durable general power of attorney, and make sure that they have their wills in order. Even though she just came to see me about a deed.
Yeah, sure.
There are other things that could help her and help her son to help the father and to help her later. So a good power of attorney and a good health care power of attorney can really be so valuable to families that want to help look after mom or help look after dad.
That's great. That's great. So when we're talking about Medicaid, one of the things that comes up. So let's say we get we get qualified, and we're going to talk about how we preserve that real property here in just a second. But one of the things that happens is if we don't do anything with the real property, it's going to become part of it's going to pass via the person's estate or however their estate plan says. And Kolin, when that happens, we get what's called a claim on the estate, right? Talk about Medicaid liens and what can happen there.
Yeah, so essentially what we're talking about here is if we kind of don't do what we're talking about here, they get on Medicaid, they're allowed to own their home to qualify for Medicaid. So they don't do what we're talking about here, the 1%, and they just qualify for Medicaid, and they still own their house. At that point, they're going to be able to, stay in their house up until the point that they pass away. And then when their loved ones are potentially Medicaid, go to open the estate, they're going to put a claim against that as a creditor against the estate, and they're more than likely, as Dave was talking about, it's really expensive to do this long-term care. So if they're in long-term care, that claim is probably going to eat up the entirety of the assets that are in that estate. So that typically includes the house. So that's really what we're looking at here, and kind of what we're trying to avoid. Get into the situation where, when the person does pass away, when Medicaid comes knocking on the estate, there's nothing there for them. And that's kind of what we're looking to do.
So where we're at is we've got mom or dad who potentially may need Medicare or Medicaid, and they may need to qualify for Medicaid, but they've got assets, namely real properties. That's because that's often the largest asset that we see people have. They want to give that to their children. They can't do that, or they shouldn't do that, as you've described. And if they don't, they may still qualify for Medicaid if it's their primary residence. But you're saying that now Medicaid's going to come and put a lien on the estate, and perhaps they're going to have to sell that real property anyway to pay that lien. So, David, what's the solution here?
Well, first of all, I want to take the fear out of the 10% of you that are saying, oh, my goodness, I'm going to have to pay Medicare back. We're not talking about Medicare.
Right. Yep.
Medicare, it doesn't matter how rich or how poor you are, Medicare is going to pay once you reach a certain age, and Medicare does not want its money back. Medicaid is mandated by law to try to get every penny back that it paid.
Right.
And so don't worry if you've got Medicare. I mean, that's fine. Your estate's not going to have to pay that money back. But Medicaid is going to try to get its money back. Now, how do we keep them from doing that? Well, we've already said it's not a good idea to deed the property over and just give it to the son because of the 5-year look-back period that Medicaid has. So what do we do? All right, here's the solution. Mom and dad sell a 1% interest in this real estate to whomever they want to sell it to. Sell to the son. Let's say the son that lives there. The son, mom and dad sign a deed from mom and dad, they're the grantors, to mom and dad for 99% with a right of survivorship, and 1% to the son with a right of survivorship. Now, Kolin, explain what that means when dad and mom have passed. Well, let's use this. I always tell them this too. What if the son dies first? He owns 1% with the right of survivorship. What does that do?
In that case, that's not what we don't want, but it would go back to mom and dad. That right of survivorship language essentially just denotes that they're going to own it together while all of them are still alive, and then when the first of them passes away, the other owners with rights to survivorship just take that person's ownership interest in the property.
And they do that automatically, right?
Automatically.
So that's the thing. We avoid that estate, and we don't have to worry about claims on that estate as much. There's maybe some chance that there could be some problems with that, but very unlikely that we would have any problem with claims on the estate if we've got that right of survivorship language in there.
You avoid probate by doing it.
Yep.
And probate is not rocket science, but it's very painful.
Yes.
Those of us that have lost a loved one and have had to handle their estate know, and I from my own experience, I can tell you, I had my dad's estate sitting in a box at my office, and I knew how to do it, but I just didn't want to face the fact that my father had died.
Sure.
And it took me about a year to do it just because I didn't want to face it. And so probate is not usually. It's not complicated, but it's painful.
Yep.
And so you do avoid probate. You avoid having the real estate go through probate by doing this 1% deed with
Sure.
a right of survivorship.
Sure. Yeah. And so we talk about, we're going to do this 1% purchase is what we call it.
Yes.
So now we're not doing a gift,
That's
right?
right.
Right.
That's right.
So
Here's how you do that. The IRS has said that 1% sale is sufficient for the purpose that we're using it. There's rulings on this.
right.
And so the son is going to have to pay 1% of that farm value, the current tax value.
So we use tax value to
That
determine
is
what
correct.
is 1%.
You do not use the fair market value, you use the tax value, and that's what the rulings have said. Mom and dad cannot give the son the money to do it.
How often do we get that question? Right?
Yes, they do.
Yeah.
Yeah, and I always explain that you cannot do that because remember, DSS is going to go back and look not only at the son's bank accounts and savings withdrawals and that sort of thing, but they go look at mom and dad's too when they apply.
Yep.
And if mom and dad have given the son the $2,500 or whatever it is that he'd have to pay for his 1%, it's only 1% that he has to pay. Then Medicaid's going to say, no, this is just a sham.
Yeah,
You
yeah.
really gave it to him. You're not eligible.
So if we've got a house worth a tax value of $100,000, son pays mom and dad $1,000, and mom and dad do a deed for that 1% with right of survivorship to the son.
And if it's $1 million, like we see farms, it's not unusual to have farmland in Iredell County that's worth $1 million, $3 million, whatever. It's still got to be 1% of that. And let's change the family dynamics here just a minute. Let's say there are 5 children, and mom and dad want it divided among all 5 of the children. Well, the 5 children just get together, and let's say that 4 of the children have money and 1 child doesn't have any money. It's okay for the other 4 to pay for that 1 child, just so mom and dad don't pay for it.
Yep.
Okay. And so we do a deed from mom and dad to mom and dad for 99% and 1% to the children. And it works the same way. One thing I do caution my clients when we do, multiple children, is that the statistics show mom and dad are going to die first. And if that happens, the children need to remember to come back and see us because they probably don't want their siblings to have the right of survivorship on their interest in the
Yeah,
farm.
let's dig into that just a little bit because we've talked about that right of survivorship and what it does.
Yeah.
But that applies to everybody
Yeah.
that owns the property now.
Yeah.
So if we have mom and dad and 1 child,
Yep.
if that 1 child dies before either mom or dad,
Yeah.
then it automatically goes back to the other one. So it may be crass, but one of the ways I think about it is it's the last man standing or last person standing.
Yes.
Whoever is the last alive
Right.
will end up with 100% of the property.
Right.
And so especially if you've got five children who are buying into this 1%, if any one of those passes away before mom and dad, it kind of clogs up the works and we need to rework it just a little bit. So that's maybe one of the drawbacks, right?
I've done that before because the family as a unit wanted that deceased child's children to have that deceased child's share. And we were able to work that out fairly simply.
And usually we can as long as everybody has a good understanding on the
Right.
front side of this is how this works.
And that's why I always like to talk to not only mom and dad, but also to all the children that will be receiving. Sometimes we run into a situation where, or many times I run into a situation where somebody will call and say, well, mom's in the long-term health care facility and we're going to run out of money next month. What do we do? Well, I ask these questions. What assets does she have? And there are, and I need to tell about this too, there are several things that you can do if mom has some money that needs to be spent down.
Right.
It doesn't have to be all paid to the long-term health care facility. If you're at that situation where mom has $20,000 and she's in long-term health care and Medicaid says, well, you're not eligible until you spend down this $20,000 to $2,000. Because in order to get Medicaid, I hope I didn't say Medicare just a minute ago.
No, I think you're good.
It's Medicaid.
Even we get confused on it, don't we, sometimes?
Yeah, you can only have your real estate You can have a prepaid burial contract. You can have a motor vehicle if that motor vehicle is used to transport the person who is applying for Medicaid to and from doctor's appointments. And most of the time in long-term health care facilities, aren't able to keep a vehicle. And $2,000 worth of other stuff. So let's say that mom lives in the house and they've got $20,000 they've got to pay down. Well, you can take that $20,000 and fix the roof on the house. Mm-hmm. Medicaid says that's fine. You can take that $20,000 and buy a prepaid burial contract. You go to one of the local funeral homes and say, well, I want to get a prepaid burial contract, and you can do that. And that leaves more finances down the road for the heirs.
Sure.
And that's what we all want. We all want our heirs, whether it's children or whomever, to get as much as they can legally at our death, and to minimize any liens that they might have.
Well, and folks have worked a long time for what they have, and if they've got a house or a farm or some of the things that we're talking about, the last thing they want to do is have to see that sold to go pay for long-term care.
I have an example, a true example, where a couple came to see me. The man's father had just died, and they got a lien from Medicaid for $200,000. Mm-hmm. That it was an actual lien. It was a letter, and it said there's a $200,000. We're seeking a $200,000 lien against your farm, and the son, the surviving son, said, well, we live there. I'm working there. Can this happen? And I said, well, your mom and dad came to see me about 5 years ago, and I pulled up the 1% deed that we had done, and I told them, because you've done this 1% deed, that lien cannot collect a dime on this farm, and cannot take money from you. You don't owe it. Your dad's estate owes it, and he doesn't have anything in his estate, and so Medicaid cannot collect it. And that couple left my office crying. They were so happy.
What a relief
that we had done that.
Absolutely.
Yeah,
it's such a valuable thing, Kolin, because you deal with estate administration constantly. We did a podcast on that just a week or so ago, and that can be David called it painful, and it is, but it part of the pain of it is it's a long process. It's an expensive process. Yeah. So on the backside of these 1% for the estate administration, you've got to see a lot of benefits to that. Yeah,
I mean, it really, in terms of real property, makes it easy as can be. Like we talked about earlier, it's automatic. There's no function that the clerk of court or the register of deeds has with it. It's pretty much already done by operation of law. With that right of survivorship language, it's done. When they pass away, the property goes to that 1% purchaser, and it's kind of outside of the state altogether.
In the case where we have, and it doesn't matter whether it's 2 or 3 or 5 or 10 1% purchasers, what do you do after mom and dad have both passed away to kind of clean that up? Because we've still got that right of survivorship on there. There's going to be some stuff we need to do on the backside, right?
I mean, there is stuff you can kind of clean up title, but really the work is done. Those people own it, and if they want to kind of change their ownership interest away from having rights of survivorship, they can do that. But at least in terms of the estate, it's kind of all said and done with that. But there is things we can do to clean up title for those other people. We want to use the 1% just to get it away from Medicaid. And then once that's done, for the 1% purchasers, we can do a whole lot of things with that real title.
It's up to them.
It's up to them at that point, whatever they want to do. But the upshot of it is that it's not going to be part of the estate recovery process, and it's saved from those Medicaid liens.
Yeah, I want to caution folks that may be watching this. I have also seen folks that came to my office that had a deed from dad and mom, 99% to dad and mom, and 1% to the son. And the deed did not mention the right of survivorship.
Yep.
And I said, I am sorry, and it's not a deed we prepared. Let me say that up front. We did not do the deed. but I couldn't help them
That's right. Yeah.
because it didn't have the proper language in that deed that is needed. So I know you can pull a lot of stuff off the internet and that sort of thing, but with the amount of money that you're talking about here potentially, it certainly is money well spent to see an attorney to help you with this planning.
Well, in that case, one of the things we talked about in our estate administration podcast was how important it is to come see us
Yeah.
before you do anything else, before you go to the clerk of court, before you do anything else after a loved one passes. Come and talk to Kolin, because he does the estate administration stuff. Show him your 1% deed, show him everything, and then we can make a decision. You know, if in that case that David describes, if we've got a client that maybe there wasn't that right of survivorship by mistake or whatever, there's things that Kolin can maybe do to even after the death to mitigate that a little bit. And there's several situations that we would have to talk through there.
Yeah.
And it's like the classic lawyer answer. It just depends on the facts of that particular case. And that's why it's so important that watch these podcasts, do research on the internet, but talk to an attorney and come see Kolin. Everybody's situation is different, and there's things that we can do to help.
Yeah, those are some of my favorite meetings to have with people is when they come in and say, are we covered? Are we good? And I get to tell them, you don't need to go see the clerk of court at all. Your loved ones don't need to go see the clerk of court at all. It's handled.
That's right.
People love that. Like David said, they leave just glowing. They're thrilled that they've done their work on the front end, so it's easy on the back end.
Yep. So if you think you might be in this situation, you guys have anything else to add on these 1% deals that we've maybe left out?
I thought it was interesting. Luke and I had a conversation about this the other day. In terms of Medicaid qualification, if you have given something away or sold real property within the last 5 years and you go to qualify, there could be a penalty that bars you out of getting Medicaid for even longer. That's if you try and qualify. So that's something I think is important to know.
And oftentimes, if you've done that and you're worried, like, oh no, what am I going to do? Most of the time, we can unwind those things and start, and we can just unwind it, undo it, and start over and kind of build the foundation that we're talking about
Yeah,
here.
and when you say undo it, we'd prepare some other documents that would mitigate what has already taken place.
Or if there's been a deed, like if they gave the property to the son just gives it right back, or something
that's
like
exactly,
that.
that's exactly.
And then we start over with this 1% process.
Yeah, that's right.
Yeah. So guys, if any questions on any of this, make sure and call David or Kolin here, either one. These guys know exactly what they need to do and what you need to do to protect the assets, to protect the family farm, to protect mom and dad's house, and to get you qualified for Medicaid. There are other things that we can do, Medicaid Asset Protection Trust, and those are a lot more complicated, a whole nother podcast that Kolin can do for you. So he's the estate planning guru now and estate administration. So give him a call.
Learn from the best.
And he can get you set up. So thanks for watching, guys. And don't forget to like and subscribe. Watch our YouTube channel. Check us out on Facebook. And we really appreciate you guys. So thank you.
The information contained in this video and audio recording is general in nature and should not be relied upon in making legal decisions. Every situation is different, and you should consult with your attorney before making any legal decisions.